I want to thank Tom. I want to thank Aaron and Melody for doing such a fine job hosting us. It's always a pleasure to be down at the Berkeley Center, which I, as director of at least like-spirited center on religion and world affairs, I look at with great envy at their success, their achievement, and their extraordinary schedule. So thank you for making time, Tom, in what is, I know, an already congested schedule, and hosting us here. It is a great pleasure, and hopefully the first of many collaborations. One of the more vexing questions all of us know confronting policymakers and governments today, governments that deal with the Muslim world and Muslim populations, is how to respond to calls for the implementation of a uniform and codified version of Sharia, or Islamic law, for Muslim citizens and for the basis of the state. Many of the activists voicing these appeals are mainstream Muslims, intent on abiding what they properly regard as God-given commands of their faith. In other cases, however, as in Afghanistan, Iraq, Somalia, and Pakistan in the 2000s, those calling for state-enforced Sharia include armed militants, willing and able to carry out spectacular acts of mass violence to get their way. Not surprisingly, this latter association, the association with violence, has cast a pall over the Sharia question. Although the primary focus of our presentations today will be Sharia in Muslim majority locales, 8 in particular, our reports speak to the general policy challenge of Sharia. Calls for the recognition of the Sharia have been heard with growing regularity in Western democracies. The appeals have even come from non-Muslim clerics and intellectuals. This was most famously the case in February 2008, when the Right Reverend Rowan Williams, Anglican Archbishop of Canterbury, suggested in a lecture given to the Royal Courts of Justice that it was desirable and unavoidable that certain aspects of the Sharia be acknowledged in Britain for reasons of equal treatment and group rights. As seen in recent legislative discussions in 14, my last count, 14 American states aimed at preempting any legal role for Sharia, recommendations like these in other countries, as well as in the UK, have provoked sometimes fierce backlash. The fact that the issue's politicization has generated more heat than light does not diminish the policy importance of the Sharia question. That's why we're here today. The issue raises questions about the fundaments of liberal democracy and about how to balance a democratic commitment to human freedoms with the equally democratic desire to allow citizens to practice their religion freely and fairly. Now, before analysts can begin to address these weighty questions, they need to get a sense of just what the Sharia is. Does Islam require that the state implement Sharia? Can the Sharia be compatible with modern democracy and pluralist citizenship? Or is the law, as some people claim, effectively human rights denying with respect to women, non-Muslims, and Muslims who profess a non-conforming variety of the faith? Few questions are more decisive than these for assessing the future of the Muslim world. Yet few have proved more confounding for Western policymakers and publics unfamiliar with Islamic law. Through a combination of case studies and comparative reflections, it's these questions that the presenters at this conference this morning will address today. A few background remarks on the project. Let me just very quickly review the background to the project. The participants in this conference first came together well before the recent public outcry in the United States over the Sharia. We began with 2 meetings in 2008, both part of a 15-month project on Sharia politics in Muslim-majority countries. The project was sponsored by my institute, the Institute on Culture, Religion, and World Affairs at Boston University, and funded by a US-based policy institute that has asked to remain anonymous. In the period between our 2 meetings in 2008, each team member, already an expert on features of Muslim politics and Islamic law, carried out research with the assistance of local partners in one of the 8 target countries. The collaborative project that was the background to this conference had 2 broad aims, both of which will figure in the presentations today in a very streamlined form, needless to say. First, the project sought to map the politics and meanings of Sharia in each of the 8 countries. By mapping Sharia, we meant that all of us sought to highlight the diverse and competing understandings of Sharia, there's not one, and explore how that agonic plurality relates to broader movements, solidarities, and contentions in society. The countries featured in our study are Egypt, Turkey, Saudi Arabia, Iran, Afghanistan, Pakistan, Nigeria, and Indonesia. Over the past generation, all of these countries have experienced a powerful resurgence of public interest in the Sharia, as was also the case with the Gallup survey subtly analyzed by John Esposito, who will be here later this afternoon or morning, and Dalia Mogahed in 2007. Our study shows high levels of support among Muslim publics for both Sharia and democracy. However, our study also reveals that the commitment to Sharia carries with it fundamental disagreements over just what the Sharia requires, how it should be implemented, and whether its entailments are compatible, in fact, with democracy. The research team's second task, in addition to mapping, was to look more closely at these last questions, exploring what the plurality of views as regards Sharia means for politics and citizenship. In particular, the researchers assessed the implications of the main currents of Sharia opinion and activism for 4 issues: democratization and citizen rights, gender relations, the place of non-Muslims and minority Muslim actors in society, and 4th, pluralist tolerance. These issues, too, will be at the heart of our presentations today, again, though, in a very, very abbreviated form. As will become clear, the presenters don't speak with a single voice. That's deliberate. They were not recruited to the project on the basis of any kind of intellectual or ideological litmus test. The sole criteria in their selection were that they were experts in Muslim politics and law in the country of their research, and that they had experience speaking to and interacting with policy analysts. Now, notwithstanding the lack of any unitary ideological compass, what you'll hear today has serious and actionable implications for policy discussion. In my remaining time this morning, I want to highlight 4 points of cleavage in the understanding and practice of the Sharia, all of which different speakers will address from different angles in the papers that follow. All 4 issues are vital for policy analysts seeking to understand the implications of Sharia for Western governments and Muslim politics. Now, my first point is a ground clearing one, and concerns just what the Sharia is and what it is not. The term Sharia is commonly translated as Islamic law. On the basis of this translation, the Sharia is often assumed to be the Islamic equivalent of Western state-based positive law. However, as practiced across the great expanse of Islamic history, the Sharia differed from Western positive law in several basic respects. For most of Muslim history, the Sharia was not a codified legal tradition monopolized by the state, but a practice of legal derivation and judgment carried out by non-state scholars. Sharia law was, to quote Knut Vikor, placed between state and civil society, not exclusively in the state. As Noah Feldman and others have recently noted, the situating of the law and its custodians outside the corridors of state power offered a serious check on state power, although the effectiveness of this check actually varied rather significantly by time and place. During Ottoman times, the jurist's autonomy was increasingly compromised as a result of the Sultan's assertion of control over Islamic judges and the madrasas that trained them. Efforts to etatize or statify the Sharia have intensified in modern times, particularly in recent decades, as radical supporters of the law have demanded that the Sharia be codified, enforced by the state, and made the sole source of all law. This singular and etatist model of the law is rejected by Muslim reformists, who rightly point out that the model departs radically, which it does, from Islamic tradition. This is but the first of several examples showing how the meaning and practice of Sharia law is not monolithic or unchanging. This is a key theme. Is not monolithic or unchanging, but subject to ongoing and intense interpretation and contestation. My second point. A second and even thornier point follows from this first and concerns the scope of the law. A definition of the Sharia closer in spirit to its historical practice would be to say that it's God's commanding guidance for an Islamic way of life, as is similarly the case with Jewish halakhic law, which it resembles in many ways. This commanding guide is a kind of total discourse in the sense that, and I'm quoting Brinkley-Messick here, all kinds of institutions find simultaneous expression: religious, legal, moral, aesthetic, and economic. As developed by classical jurists, the Sharia offered guidance then on everything from prayer, diet, inheritance and dress, to commerce, taxation, and public warfare. In terms of its sheer volume and scope, the bulk of the Sharia is concerned not with statecraft, but with things like worship, hygiene, etiquette, and Muslim sociability, matters that in Western legal tradition would not likely be considered law at all. The here and there-edness, we might say, the here and there-edness of the Sharia, the fact that in principle it's supposed to be an encompassing guide for an Islamic way of life, takes us deeper into my second point today, as to how and why the Sharia is subject to such divergent interpretations. Although most scholars of the law agree that in principle the Sharia is an all-encompassing guide for a Muslim way of life, in practice, as you'll hear today, they do not agree on the guidelines provided for all social domains. Handbooks of Islamic law, popular in earlier times, devote much of their attention to the proper forms of Muslim worship, or ibadah. Indeed, compared to other religious traditions like Christianity and Judaism, Muslims have shown an impressively high degree of agreement on basic devotional matters like how to pray, how to fast, all of which, remember, are regulated by the Sharia. However, the further one moves from the details of worship to questions of social and political life, the greater the disagreement over the Sharia's message and proper mode of implementation. Islam's classical jurists were aware of this fact. Indeed, it's for this reason that most took care to distinguish the divine sources of the Sharia from the all-too-human rules for living derived by scholars from these sources. The latter are, of course, jurisprudence, or in Arabic, fiqh. Fiqh is anything but monolithic. Indeed, it's more fissiparously pluralistic today than it was even in classical times. To curb the tendency towards sectarian fission and kind of an excess of rival interpretations, Muslim scholars of the law in earlier times organized themselves into schools and developed educational institutions for the teaching of a more or less common or standardized understanding of the law. Nonetheless, the basic fact remains, and it has to be emphasized in the face of some characterizations of Sharia we hear in the media today. The Sharia is richly detailed on some matters, but silent, undeveloped, or simply circumspect on others. My second point on the Sharia then can be summarized as this: comprehensive in principle, all-encompassing in principle, the Sharia in practice is unfinished, ever-evolving, and uneven in its coverage. Now, why bother to emphasize the Sharia's unspecificness, its here and there-edness, as I said, on some matters? One reason is that today radical proponents of the Sharia, like the Taliban and Al-Qaeda, deny this religious and legal plurality. These radical proponents insist that the Sharia is fixed, finished, and easily intelligible. It doesn't take a scholar to understand it, we hear. Because it's easily knowable, anyone who doubts what the radicals regard as incontrovertible is at best a fool and at worst an apostate. For militants like these, the only way of dealing with apostates is capital execution. This brings me to a related point. My third point is regards policy analyses of the Sharia. Disagreements over the scope and meaning of the Sharia are especially heated with regards to Muslim politics because on matters of state, the Sharia is especially unspecific, unfinished, and contested. I realize some people would disagree with that, but that's my point. That the Sharia does not offer a simple blueprint for state organization is, of course, a view, again, at variance with understandings of Sharia promoted by pioneers of Islamist thought, like the Egyptian Sayyid Qutb and the South Asian scholar Sayyid Abdul al-Maududi. For these writers, Islam's Sharia provides a complete, absolute, and finished guide to politics. That blueprint allegedly stipulates that Islam does not allow any separation of religion and state because both must come under the commanding control of the Sharia. However, whether in scripture or classical jurisprudence, one looks in vain for evidence of any such finished blueprint. What there is instead, as today's reformists insist, is a general ethical spirit of relevance for matters of justice and public ethics. The absence of any detailed blueprint is also demonstrated in the fact that all Muslim societies have developed legal and political traditions beyond those stipulated in the Sharia. Among other things, all Muslim societies have been marked by legal pluralism, the coexistence of several different traditions of law. This pluralist legacy is, of course, denied by some among today's radical activists, but affirmed and embraced by reformers and the Muslim mainstream. Now, thus far, my remarks suggest that there was and is not one but many understandings of the Sharia, and that reformists who wish to interpret the law in a more pluralistic manner can rightly point to Muslim history for precedents. Having affirmed the existence of these pluralist resources for a kind of scaling up of the Sharia into a pluralist and even democratic variety, let me, as my fourth point, my last substantive point today, also emphasize that other aspects of the law, as classically understood, I emphasize that, present challenges to those hoping for a democracy-compatible Sharia. Although it offered few specifics, no blueprint on state organization, the Sharia, as classically developed, provided extensive commentaries on women, non-Muslims, and Muslim nonconformists, those who had a nonconforming understanding and practice of the faith. And in all three cases, the law, as classically developed, stands in striking tension with modern democratic viewpoints, especially those of democratic Muslims. As regards women, for example, in matters of marriage, divorce, property, and inheritance, women in Islamic law were accorded far broader rights than they are thought to have enjoyed in pre-Islamic Arabia. Or for that matter, their rights were more extensive than their sister counterparts in Western Europe. There's no question about that. Adult women could own property, they ran businesses, and they set up pious endowments, waqf, to support schools, baths, and other institutions of public benefit. Indeed, on a very, very large scale, they did so. Nonetheless, in court testimony, in inheritance, divorce, and public movement, women's rights were markedly inferior to those of men. In modern times, textual conservatives have cited precedents like these to argue that gender equitable understandings of citizenship and Sharia are contrary to Islamic law. The law's stipulations with regard to my second issue, non-Muslims, shows a similar discriminating or differentiating tendency. Departing from the ecumenical spirit of verses from the earlier Meccan period, some classical jurists cite Surah 929 in the Quran to argue that there is an enduring tension between Muslims and non-Muslims. They used this citation, the classical jurists, some classical jurists, to justify discriminatory restrictions on the public rights movement and the presence of non-Muslims. As in Mughal India and the Ottoman Empire, however, many Muslim rulers set aside these harsh restrictions that were in the law when dealing in practice with their non-Muslim subjects. Nonetheless, the letter of the law, a critical point, the letter of the law with regard to non-Muslims was never effectively rewritten. Today, it's been invoked by radical interpreters of the law to justify opposition to equal rights for non-Muslims and to point to enduring hostility between Muslims and non-Muslims. Arguably, the most serious tension in the historical Sharia, however, concerns questions of religious freedom, the most challenging aspect of Sharia, not least of all with regards not to non-Muslims, but to Muslim nonconformists accused of doctrinal deviation or blasphemy. Certainly, we have to remember comparatively, the medieval Muslim world had far less of the inquisitional persecution and mass killing that blighted early modern Europe. No question about that again. In their writings, too, Muslim jurists took care not to apply the accusation of apostasy broadly and to require high standards of proof for a conviction. Nonetheless, the letter of the law deals harshly with apostates and religious deviants. Today, radical Islamists cite these precedents to justify anti-blasphemy campaigns that curtail the freedoms of millions of fellow Muslims and threaten non-Muslims, as we've seen recently in Pakistan. Muslim Democrats point out that such actions violate the oft-cited injunction in Quran 226 that there is no compulsion in Islam. In short, my fourth point is that on all of these issues, women, non-Muslims, and religious freedom, The Sharia, again, as classically developed, stands in tension with the democratic principles enshrined in documents like the U.S. Constitution and the 1948 Universal Declaration of Human Rights, even where the majority of Muslims develop views at variance with this earlier legacy, which they are. The activities of an intense minority committed to an unreformed and anti-democratic understanding of the Sharia will continue to challenge modern Muslim politics for some years to come. Time is short, so let me finish with a few general policy conclusions. Very, very quick. The first is basic and repeats what I've emphasized this morning. There is no single understanding or practice of Sharia around the globe. The Sharia was never monolithic or unchanging in its meanings. Today, the cacophony of meanings is greater than ever. Contestation among rival understandings of the Sharia will figure in Muslim politics and society for many years to come. My second point follows from the first. It's that the law is no longer just a matter for small circles of scholarly virtuosos, but has been publicized and politicized by being drawn into the contestations of modern mass society. This process takes different forms in different countries and different places, but as you'll hear in the case studies today, the trend is indisputable. The publicization and contestation of the law is one of the main drivers for arguments over the practice and meaning of the Sharia today. My third conclusion is sobering and cautionary. Where Sharia-mindedness is widespread, a concern for implementation of the Sharia is widespread, but frameworks for civic and fair participation are weak, and where factional struggles for the state overlay deep ethno-religious divides, we can expect that some radicals in the Muslim community will invoke an exclusivist and totalitarian understanding of the law. They will use that understanding to develop frames for social mobilization that criminalize dissidents, sharpen divides between Muslims and non-Muslims, limit the rights of women, and persecute Muslims seen as deviating from the radicals' absolutist line. My fourth point, however, is the most critical, and it is that there's a strong countercurrent, indeed a dominant countercurrent to this absolutist and totalitarian use of the law. In Turkey and Indonesia, in the courageous efforts of the Arab Spring, and in study circles in the West, one hears talk today not of an exclusive and totalitarian absolutist Sharia, but a Sharia of justice and plural ethics. Proponents of this latter Sharia aim to bring the law into alignment with the higher objectives and ethical goals, the maqasid al-Sharia, of Islam's general message. I'm quoting Tariq Ramadan here. Elsewhere, in a book that resulted from this conference, from this project, I've suggested that what we are seeing in these processes might be called, I know it's controversial, the citizenization of Sharia. Whatever one chooses to call it, the current is a growing influence all around the world, and it's a hopeful and positive influence. My fifth and last point today is that policymakers can most effectively assess the contest between these rival visions of the Sharia by, first of all, acknowledging the existence of the plurality of Sharia opinion and rejecting those Western analysts who, though well-intending, claim that there is, and I'm quoting a source here, ultimately but one Sharia. Policy analysts can also effectively engage global discussions of Sharia, not by meddling directly in legal arguments where they have no training, but by recognizing that Muslim public opinion on the Sharia is not static, but responsive to the same social forces that democratized public religion here in the West. Mass education, balanced economic growth, global justice, the rule of law, and, very importantly, the education and empowerment of women. These same social forces are transforming Muslim-majority societies all around the world. They're also creating powerful pressures for an ethicalized and citizenized understanding of Sharia law. Thank you. We're going to move directly. We're on a very, very tight schedule because this room is going to be used by Tom's ever-active center immediately after we finish today. So we're going to move directly to our first speaker, who is Frank Vogel, emeritus from the Harvard Law School, speaking on Saudi Arabia.
Thank you very much. Great privilege to be here. I look forward to today's discussions. My assignment is Sharia politics in Saudi Arabia. We should start with a reminder that the status of Sharia in Saudi Arabia is quite distinct from that of other Muslim countries. In most Muslim countries starting roughly 150 years ago, law and legal systems were transformed according to Western patterns. But in Saudi Arabia, in contrast, Sharia, in its local form, developing continuously over several centuries, has remained the fundamental framework not only for religion, and not only for the country's laws and constitution, but also for its politics and governance. In communal and social spheres as well, Sharia is the generally acknowledged source of norms and values. Therefore, while in other countries we'll hear about today, Sharia may be merely one ideological option on offer, in Saudi Arabia, Sharia is relatively hardwired into governance, politics, law, and daily life. This leads to one of the main points I wish to leave you with today, sort of take away, that given the role for Sharia I've just described, when we wish to ask a question about Saudi Arabia, not only religious or legal questions, but also political and social ones, we need to take care to frame our question with a Sharia template in mind. How do the forms of Sharia extant in Saudi Arabia inflect what we ask and the answer that we hear? As to not only rules, but also delegations and authorities and variations in process. I don't think I stand convicted of essentialism by pointing out that because of Saudi Arabia's constitutional law and because Sharia is the primary constitutional law and source of political and social values, and these are consciously derived from Sharia on all sides, specifically this local notion of Sharia, we should be careful to consider this Sharia template when we frame our issues and observations. In the United States, we certainly understand that our politics and government are framed and nuanced by the manifold laws, processes, and authorities of our constitution and legal system, which has its own continuous several-century history. Similarly, in Saudi Arabia, for whatever issue we are addressing, whether popular participation in government, capital punishment, official corruption, legal rights of women, and on, it is useful to consider how Sharia, according to various local interpretations, as an initial matter at least, frames and nuances that issue. Let me make 3 quick clarifications at this point. First, I don't mean that there are not other vital templates with which to understand Saudi Arabia. We're mainly talking about Sharia politics today, after all, such as the rentier state theory, patron-client networks, regionalism, tribalism, sectarianism, state building, modernization, development, evolution of Islamist dialogues, ideologies. A number of valuable new studies happen to have just appeared on Saudi Arabia, sort of shedding new light on the country after many decades of really remaining in the murk. All of them are based on the ground research in the country, so I'll refer you to these if you're interested. Second, I'm not saying that the Sharia template, a second caveat is I'm not saying the Sharia template itself is uncontested. That's the interesting part about it. Or that views as to Sharia are not plural in the kingdom. The contrary will come out as I go along. Third, I don't mean to suggest that Saudi Arabia can never change as long as it enshrines Sharia, as it does. In fact, it's just noted interpretations of Sharia vary, and the rules, systems, and practices by which Sharia is applied in Saudi Arabia have already evolved considerably and will continue to do so, seemingly very rapidly. In the original paper included in the volume, I outline a number of ways in which approaching Saudi Arabia with the Sharia template in mind can assist our understanding of Saudi Arabia. Here I can mention only one. Because it for so long avoided westernization, the constitutional system of Saudi Arabia reflects the constitutional system that ruled most of the Muslim world for a millennium or more. It is best labeled by the Sharia doctrine defining it, siyasa Shari'a, or governance in accordance with Sharia. This system divides the finding and applying of law into 2 complementary modes, both under the aegis of Sharia. This is a point I need to insist on. Many commentators consider this largely outside Sharia. This system divides one mode represents law, one mode of lawmaking and application represents laws found by religious legal scholars and applied by them in religious legal courts. Law in this mode is fiqh, as mentioned by Bob, meaning the jurisprudential opinions of scholars. The other complementary mode is that of laws and tribunals dependent on the ruler. This is the siyasa side, and his political establishment. The ruler exercises a power called siyasa and deemed delegated to him by Sharia itself to make laws to serve the public interest, or maslahah, dependent only on the requirement that these laws not contradict basic Sharia principles. These two modes of law are thus distinct and complementary. Fiqh, purportedly derived from timeless scripture, and siyasa, a utilitarian solution to contingent needs. Fiqh, innately suited to private law, to the private side of the legal spectrum, and siyasa suited to the public side, or public law. Siyasa dependent on fiqh for legitimacy, and the scholars, and fiqh dependent on siyasa for worldly power and implementation. The dynamism and tensions inherent in this coupling lent innumerable pre-modern legal systems an historically adequate degree of constitutional checks and balances and of compromise between ideal and necessity. So how does this system apply in Saudi Arabia? From the beginning, the Saudi state has portrayed itself as a partnership between the rulers from the Al Saud family and the scholars of the Wahhabi movement. Until today, constitutional responsibilities are divided between king and scholars, as just described. As to law on the private and civil side, such as laws of contract, tort, and property, these remain uncodified, in theory left open to scholar judges to determine for each case, though in practice judges generally observe one of the four Sunni schools of law, the Hanbali. As for law on the siyasa side of the divide, most laws affecting the public sphere and the state fall within the discretion of the ruler to determine. He has power to issue statutes called nidam, meaning regulation, as public need demands, subject only to avoiding outright contradiction with Sharia principles. The courts applying Sharia generally decline to apply the laws issued by the king, so for important laws he usually creates a specialized tribunal to apply that law, resulting in not only a dual system of laws, but a dual system of courts. Obviously, if Saudi Arabia has such a constitutional and legal system, in seeking to understand the country, again, this is an example of a Sharia template we need to use, we have to make many adjustments in our usual understandings and not be too beguiled by the fact that Saudi Arabia has adopted many of the trappings of a modern nation state. Yet one finds that commentators on Saudi affairs typically ignore this constitutional system. For example, commentators have routinely, for many decades, underestimated the influence of Saudi Sharia scholars in particular issues, leading to many failures of prediction. One can trace how reform after reform announced by the government has stalled out precisely at the point where scholars interpose some Sharia-based objection. Similarly, it is often claimed that the ulama have been co-opted, preempted, disempowered. This has been done repeatedly. But the evidence for this is often simply the fact that the scholars have accepted salaried positions with the state, or that they have acquiesced in some issue of public law or state policy to the judgment of the king, or that they avoid publicly criticizing the ruler for his defaults. But all of these behaviors, as I've partly explained, are largely dictated by the Saudi constitutional system. For the remainder of my time, I would like to discuss two main fields of contemporary development in Sharia politics in Saudi Arabia. Both of these have to do with observable dynamics, potentially reconfiguring how, with respect to Sharia, Saudis see legitimacy and power allocated among the king, the scholars, and ordinary citizens. First, I'll take up various reform programs sponsored by King Abdullah that invade domains of scholarly authority. This is between the king and the scholars. More than any king since Faisal, who died in 1975, Abdullah has pressed such reforms, first as crown prince, and then from 2005 as king. I will refer briefly to three areas, in all of which the king has initiated projects bearing his name. The question in every case is how successful in the end these reforms will be. Will they founder against scholarly opposition, as so many have in the past? First, the king appears to be making efforts to diversify his sources of religious legitimacy away from the Wahhabi establishment, by which I mean those scholars who both support the state and in most cases occupy positions within it. As scholar Stéphane Lacroix has recently clearly elucidated, the king now has scholars to whom he may turn to affirm his religious legitimacy, who, while still very Wahhabi, are one or two steps removed from the establishment. These are the scholars of the Sahwa, or the awakening movement, in its various branches. After a spate of radicalism following the 1990-91 Gulf War, most of these scholars have reverted to the traditional pattern of supporting the state while still practicing independence from the establishment. One branch of Sahwis, referred to by Lacroix as Islamo-liberals, have emerged as supporters of many progressive changes as to both constitution, law, and policy. With potential allies like these, less entrenched in the status quo and more open to reform ideas, King Abdullah seems to enjoy greater freedom of movement and potentially greater international religious status. Under the same heading, even before he was king, Abdullah has reached out to religious groups ordinarily disdained or anathematized by Wahhabi divines. He has made pointed gestures of ecumenism, domestically with several Shi'i and Sufi groups, and internationally by organizing conferences of world religions. A second major area in which the king is pushing reforms is the Sharia judiciary, the greatest redoubt of scholarly power. In 2007, the king launched a $2 billion project to increase the ranks and quality of judges and build up the judicial infrastructure. He issued a new regulation of the judiciary, creating a new Supreme Court, thus diminishing the formerly all-powerful Supreme Council of the Judiciary. When 2 years later he realized that recalcitrant conservatives were blocking his reforms, the king issued an order reshuffling the leadership of the judicial and scholarly establishment. But interestingly, until today, his most important reforms remain stalled. Third, education. King Abdullah has taken a series of steps to free education from some of the traditionalizing trammels imposed by scholars. Girls' education has long been under the control of scholars, but in 2003, the king ordered it incorporated into the General Ministry of Education, and in 2009, he appointed a woman as deputy minister in charge of girls' education, the highest office in Saudi government ever occupied by a woman. In higher education also, the government is eagerly encouraging and funding liberalization. The king lavishly endowed the new King Abdullah University of Science and Technology, an independent research university near Jeddah. Its campus is free of the social and intellectual strictures applying elsewhere, even allowing the mixing of the sexes in classes, a point attracting fierce critique from some religious scholars and the conservative public. We can observe across all these three areas the sort of push and pull between the scholars and king common to issues of Sharia politics in Saudi Arabia. A general point to take away is that the king's decrees are not enough to ensure success. Even now, it is unclear how much headway these reforms will make. The second main field of Sharia politics to discuss is the apparent emergence of the Sharia public sphere, the citizenization of Sharia that I mentioned. Yeah, okay. I can stop there. I can say that this phenomenon he's mentioned, citizenization, engagement of the public in Sharia issues, and the new attention to the maqasid of Sharia, the objectives of Sharia, is roiling the Saudi public. They're very engaged in it, and this is partly due to the vastly improved education Saudis have, particularly in matters of religion, the internet, and so forth. So we're looking forward to many important dialogues among Saudis on these objectives of Sharia and other general goals of Sharia.
Thank you very much, Frank. I should mention that we're going fast so that we have a discussion period after the first block of papers, and then there'll be another one after the second block of papers. Our second speaker this morning is Nathan Brown from George Washington University, talking about consensus and cacophony, debating the Islamic Sharia in 21st century Egypt.
Thank you very much. This microphone is working? Okay. Bob, you started off with something very, very clever where you said the Sharia is contested, and if you don't think it is, that only proves how much it is, right? And I think that argument is essentially correct, okay? The degree to the extent to which people contest, the contestation of the Sharia only deepens the debate over it. And I think this very much applies to what's going on in Egypt right now. When this project began, I was dealing with a very different Egypt politically than the one that exists right now. But in a sense, those kinds of trends, I think, have become only accentuated. But I want to start not with the contestation, but with the emergence of an apparent consensus, and I should say a real consensus, about some certain features about the relationship between Sharia and politics in 21st century Egypt. And let me begin simply by telling you something that I saw at the end of July when I was in a visit to Cairo, and there was a massive demonstration in Tahrir Square, in which various Islamist movements, particularly Brotherhood and especially various Salafi movements, predominated. And the phrase that I heard chanted primarily by the Salafis during the demonstration was "no principles above the Constitution." Now, this is, in a sense, kind of odd, because this is a movement that defines itself by fidelity to texts that are not of human derivation, and the idea that a human-authored text, that one that is to be authored through a majoritarian democratic process, is what has to be the highest principle in political life, is a new argument for Salafis to be making. They're making it with some reservations and some qualifications, so I don't want to push it too far. But in one sense, there seems to be a consensus in Egypt that yes, the Sharia is very much relevant to social and political life, but that has to be understood in specific ways, and sometimes, and to the extent that it becomes binding, it has to become binding on individuals through the regular constitutional and even democratic political process, rather than above that process. So, is there some sort of real victory for this kind of approach to Sharia? Yes, but what it does, what that apparent consensus obscures, are some very deep differences about how to apply Sharia and who is going to interpret it. And those differences play themselves out very on a daily basis in Egyptian politics, and are increasingly playing themselves out in contestations within the Egyptian state apparatus itself. So what I want to do is to talk a little bit about the victory, kind of that apparent consensus, kind of unpack it a little bit. What are sort of broad trends, which many, with Egyptians from various political and religious orientations are participating in? What is it that they could sort of agree on, or where the consensus lies, but also where the real differences are. The victory partly has to do, and is most, I think, marked with some trends that have come up both in what Bob had to say and what Frank had to say about Saudi Arabia. And that is to say that yes, the Sharia is very much relevant to personal life, to social life, to political life in the modern world. But certain sort of themes have emerged in discourse about the relationship between religion, society, and state that emphasize what I would say are general principles and the need to find interpretations that are appropriate to the particular conditions prevailing today. The one word that comes up, actually not completely across the religio-political spectrum, but across most of it in Egypt today, is wasatiyas, what is often translated as centrism, or kind of loosely as moderation. But at core is the belief that what the Sharia is about are divine instructions that are very much in the interests of the community as a whole and of individual Muslims to follow. And therefore, when interpreting and applying the Sharia to personal or political or social questions, it makes sense to try and do so in a way that facilitates social and political life. The Sharia should not be burdensome. It's good for believers, and that's connected to a great elevation in discourse about the Sharia, about maslaha, public interest, again, something that has already come up. Now, sometimes these terms are employed very, very loosely in ways that I think would make a traditional scholar blush or cringe, and yet they can sometimes lead to some startling interpretations. For instance, on apostasy, you hear this argument right now in Egypt, even from people who I would say come from a fairly traditional religious religious training, that would go something like this: the execution for apostasy is certainly something that is very firmly rooted in core religious texts. But it has to be understood still within social and political context, in which apostasy was often understood not simply as a personal renunciation of belief, but as active betrayal of the community. And therefore, an apostate is somebody who is, in a sense, not merely somebody who believes the wrong things, but somebody who is actively a traitor and an active danger. If there is a form of apostasy which is this quiet disbelief, there may be punishment in the next world. That is in God's hand. It is not a matter for hudud, for criminal punishment in this world. So the traditional understanding of apostasy is very accurate, but not necessarily applicable to somebody who simply quietly says, I don't believe anymore. That person may be bad, that person may be evil, and yet it's not relevant to criminal penalties as would be implemented by the state. That's a kind of interpretation. Exactly how new that argument is, I don't know. But it is one that I think is actually fairly widespread among people, even those with a religious, as I say, with a traditional religious interpretation in Egypt today. A couple other trends that I would mention that, again, drawing on things that Bob and Frank spoke about generally, and then for Saudi Arabia. Ethicalization of the Sharia, this a little bit less widespread, but still very marked. Egyptians will often talk about sort of a religious revival, and one form that takes is an attempt by Egyptians essentially to try and understand not simply broad social and political questions, but personal behavior. What is it that I should do as a good Muslim? I have a very strong tradition that should inform my personal practice in all kinds of ways. How I conduct my business, how I conduct my relations with my family, and so forth and so on. The interesting thing is, as I'm a political scientist, so this aspect of Sharia discourse in Egypt doesn't really attract my interest because it's not always political. And so I wasn't really sensitive to it fully, I think, when I was doing the project. But going back and looking at it, it is to me interesting that this doesn't necessarily connect to any kind of easy kind of, I mean, it sounds, in a sense, almost secularizing the Sharia. It might be relevant to you might sort of think of it as one that lends itself very easily to sort of liberal politics. And no, I think it actually takes place across the spectrum. In a sense, this is what an awful lot of the Salafi revival in Egypt is about. It's about trying to understand personal behavior and emphasis first on personal behavior. When these people enter the political realm, they're not liberals and they're not seculars. But that trend is going on and taking very different forms. A second trend, again, is citizenization. These are very different, and I think the ethicalization and citizenization pull you in different directions, but they're not necessarily contradictory, and they're sometimes pursued by the same groups. The idea that when you are socially and politically engaged, there are elements of that Sharia tradition to draw on is very, very strong element, and it has to do a lot with what Bob was talking about. Polls indicating Sharia is very much relevant to social and political life. How you interpret it is one thing, but the idea that you have this sort of legal and ethical and moral tradition that somehow becomes irrelevant the moment you step into social and political life is one that has very little purchase in contemporary Egyptian political debates. Okay, so Egypt sounds like a wonderful, consensual, and happy place where pious people interpret their religion and have no real disagreements or debates. I think there are differences. There are deep differences. And we're going to see those played out very actively in Egyptian politics over the next few years. All kinds of differences about how to interpret. That is to say, there may be great license to reinterpret in some new ways, but how do you do so? But the most interesting debate for me as a political scientist, I would say, would be debates about who can participate in these debates and who has authority to make answers and to develop answers. Is this something that is incumbent on all Muslims? Is this something that is that most ordinary Muslims should do so only under the guidance of people who have training? If so, who? What is the role of state institutions in interpreting this? And what I came in with, well, let me just pursue this a little bit. You can see this kind of debate played out in any kind of ways. The most obvious way is a great debate over what's called, I'm not quite sure, sort of spontaneous or cacophonous fatwas. A concern among many Egyptians that there's all of a sudden a monopoly, not a monopoly, just the opposite, a complete breakdown. If you want a fatwa, you can go to anybody, basically an interpretation of religious teachings. You can go to anybody and find anything that you want, and that the main religious authority in Egypt right now has the name Google. Okay, you want to know a question as a good Muslim, you just type in the answer, and out will fly, Yusuf al-Qaradawi in Qatar says this, and Al-Azhar says that, and by the way, the Salafi Sheikh says this, and so forth and so on. And there's a little bit of a debate about even whether that's a good thing or not. I mean, as you could understand, pious Muslims say it's great, everybody's participating in this debate. And individual Muslims have to find their way through this forest of fatwas. But the dominant approach seems to be, especially among religious scholars and especially among political officials, is what is going on here. Ordinary Egyptians are going to be completely confused if they're told one thing one day and one thing the next. So what are the political implications of this, specifically for the way that Egypt is going to be governed and reconstruct its political system? I began with the project with a bias, again as a political scientist. And what we had seen in Egypt over the last 100 years or so was what might be called a statification, or a tautization, I think is your term. A statification of the Sharia. That is happening. That basically what has happened is that state institutions have greatly asserted a very strong role. Ministry of Education teaches religion in the schools. There's a set of textbooks. There is an institution called Darul Ifta, where an official body for issuing fatwas. The main institution of Islamic learning in Egypt, Al-Azhar, is essentially nationalized and closely controlled by the state. Other state universities, secular universities, Cairo University, Ain Shams University, have Sharia faculties. So in all these ways, the state is asserting control. And even the judiciary, and essentially a secularly trained judiciary, has authority for interpreting Article 2 of the Egyptian Constitution, which says the principles of the Islamic Sharia shall be the principal source of legislation. That is happening. The statification of the Sharia is happening. But in a sense, what I realized as a result of this project, or what I came to realize as I heard all these voices, is that what the state has done is not completely monopolize religious interpretations, but take these vast array of interpretations and multiple authorities, and in a sense folded it within itself. You see this played out right now in contemporary Egyptian political debates about how to draft a new law for Al-Azhar, how independent Al-Azhar is going to be. An attempt by the Al-Azhar sheikhs, the religious scholars within Al-Azhar, to elect their own leader, which would essentially make the Egyptian state speak on Islam in a voice of religious scholars. They would lose a lot of the central control over it. And so that's kind of what's going on. So that rather than a steady increase in state domination of religion, there's a more subtle process taking place in which political authority shapes religious interpretation, but in which debates over proper interpretation are replicated within the state apparatus itself. And the success of the state to monopolize religious interpretation has been uneven, but the undeniable effect is to merge debates about religion and politics. And perhaps most remarkable is the way in which the state effort has led to the emergence of multiple and competing voices within the state itself. 2 more sentences. The attempt to promote and control uniformity has not completely backfired, but has brought some of the divergence of interpretation inside of official channels, or to use a different metaphor, the attempt to subsume the Sharia has resembled a boa constrictor working to digest an elephant. The shape of the serpent dramatically changes as a result of the audacious effort. Thank you.
Thank you very much, Nathan. Our next speaker is Bahman Bakhtiari, whom I have misidentified, even though I've known him for many years. I've misidentified him as at the Wilson Center. He's actually the director of the Center for the Study of Global Civil Society in Salt Lake City. He's going to be talking about Iran, Sharia politics, and the transformation of Islamic law.
Thank you very much, Bob. My task in this project was to look at the Islamic Republic of Iran, and was not an easy task, because if one looks for contestations over the interpretation of Sharia, and if one looks at for who should participate in that debate, the clerics or the non-clerics, and what are the role of institutions, constitutional structure in a country created to be a balance between Islamism and republicanism. When it comes to the debate on Sharia, what does the debate on Sharia do to the Republican component of that constitutionalism? What does it do to the Islamic component of that constitutionalism? So in a case of Iran, we see a counter Sharia movement taking place. As much as we see in Egypt, in Saudi Arabia, and other countries, a plurality of debates over Sharia that are framing itself in the ethical, spiritual context and letting the state decide which one is best incorporated. We see in Iran a counter to Sharia movement, particularly on the part of the women and the intellectuals who have emerged since 1979 and debating really the validity of that project. So in many Muslim societies, there is a great deal of popular enthusiasm for strengthening criminal codes by relying on Sharia ruling. According to one poll, 66% of Egyptians, 60% of Pakistanis, and 54% of Jordanians say that Sharia should be the only source of legislation in their country. Islamist political parties, like those associated with the transnational Muslim Brotherhood, make the adoption of Sharia the most prominent plank in their political platform. However, Iran's Islamic experience has led to a very different viewpoint about Sharia and its suitability for modern legal structure of a Muslim country. Studying the Iranian case shows how difficult it is to implement laws based on Sharia. Immediately following the 1979 revolution, Iran's official Islamization program had positive connotations for many Iranians who participated in the revolution, and they believed that it would restore the rule of the traditional law from their perspective, a law that envisions the application of Islamic law under the auspices of mujtahids, distinguished jurists, and would ensure perfect justice. They soon learned that the political process in Iran, dominated by the clerics, is anything but that. The state interest and the Sharia interest are coming to conflict, but yet the state's interest and protection of the state power is ultimate goal of the players. Yet the disillusioning experience of the clerical despotism since the revolution of '79, corruption, gross mismanagement of Iran's faltering economy, harsh suppression of dissent, and an even harder version of criminal justice codified as the Islamic Penal Code have provoked increasing alienation and anti-clericalism in Iran. Although Iranian rulers continue to talk of fealty to Islam and rules of the Islamic law, they have had a difficult time juggling different types of laws within one system, creating tensions, incongruities, and confusion. Moreover, by assuming powerful public positions in government, clerics have reduced the status of mujtahids to that of government officials. Khomeini, the founder of the Islamic Republic, even went as far as contending that laws that violate Sharia are binding as long as they serve the interests of the governing elite. In a 1987 ruling, he issued a fatwa that argued that if the state forbids you from performing pilgrimage or do your prayers, you should go ahead and do it, regardless what the Islamic principles call on you to do. We have to understand a little bit of the background to this, so if you would be patient with me, I would like to place the context of this information that I've been talking to you about. Before the 1979 revolution, Iran was the country that was ruled by a regime under the Pahlavi dynasty. Government officials, secular intellectuals, and anti-religious elements portrayed Shia Islam as the cause of backwardness, superstition, and corruption. These characterizations were accompanied by bitter and persistent attacks on the ulama, who were held responsible for corruption and moral degeneration of the existing social order. The prominent writer Kasrafi, whose works were widely published in the 1950s, made that point. Pahlavi governments encouraged nationalistic message that increasingly portrayed Islam as an alien faith imposed on Iran by an inferior civilization and a backward ethnic group, that is the Arabs. In the end, these attacks on the ulama, along with the state's programs of top-down secularization, sowed the seeds for the Islamic Revolution of 1979. Ayatollah Khomeini remained relentless in his opposition to the regime. Although forced into exile in '63, he was to emerge as the leader of the Islamic Revolution that overthrew the Shah in 1979. After the '79 revolution, he and his followers started the process of implementing a new doctrine introduced by Ayatollah Khomeini, the rule of the jurisconsult, velayat faqih. According to this theory, the clergy, in the absence of the hidden imam, were the true guardians of the state. The assumption was that because the ulama are charged with interpreting the Sharia and lead the community on the right path, it followed that they should also guide the state as well. The clerical rulers loyal to Ayatollah Khomeini were determined to protect this principle. They incorporated the principle into the Iranian constitution and made it a paramount principle that all laws within the constitution will apply to that principle. Despite the lack of consensus at a time of founding and introducing this principle, they remained relentless in imposing it. The model does not exist in the literature of the classical Shia jurisprudence. Indeed, it is found nowhere else than in the writings of Ayatollah Khomeini. The ascendance of a single senior cleric to the summit of state power and the delegation of extraordinary legislative authority to that cleric has the ironic effect of placing the autonomy of other mujtahids in question. In 1979, many senior religious leaders warned the Islamic rulers about this lack of consensus and potential impact on Islamic faith and principles. A senior Ayatollah named Ayatollah Qassim Shariat Midori was the foremost opponent among these senior clerics. Shariat Midori was a senior mujtahid with a wide following, particularly in the Turkish areas of Azerbaijan and urban areas of Tehran, Esfahan, and Mashhad. In 1982, Shariat Midori was implicated, quote, in a conspiracy to overthrow the regime. He was arrested and then defrogged, excommunicated by state authorities. The measure taken against him were unprecedented in Iranian history. The argument was that he opposes the theory of the jurisconsult and Khomeini. Never before had a senior cleric had been defrogged and publicly humiliated by another group of clerics. In 2008, the late Ayatollah Montazeri, one of the people who collaborated with Khomeini on this theory, turned completely against the concept. In what is probably his most startling attack on the authority of the concept, he declared Khomeini's theory of the jurisconsult shirk, polytheistic association, a grievous sin in Islam. Montazeri's grounds for condemning Khomeini's principle of faqih's authority was no less interesting. His fatwa stated the following: the views of the faqih have priority over the views of other people only on religious matters, and talking about other issues, such as relations with the US or having political relations with other countries, are not the business of the faqih, and therefore must be resolved by professional experts, unquote. Coming as a senior cleric, this is a direct attack on the velayat faqih principle and the politicization of Sharia in Iran. The disagreements among senior clerics over the extent of Khomeini's authority and the reach of the state undermine not only the prestige of the clergy and their influence with citizens. But more importantly, it undermined their argument for adoption of Islamic models for civil and penal codes of the country. Adopting Sharia-based civil and penal codes only exacerbated the situation further when results were exactly the opposite what they had expected. The new Sharia-based family law, which was introduced after the revolution, is a good case to explore. Contrary to stated ideals in the law, the consequences of the laws have been so strikingly out of touch with contemporary social realities in Iran, popular notions of justice, and women's aspiration, that the clergy and lay people alike have felt compelled to rethink the idea that Sharia is immutable. In examining the proceedings of divorce courts, one source found that judges prolonged the proceedings and were reluctant to grant women's petition on the allowed legal ground. Another body of research indicates that the change in the civil code did not have any of the hoped-for effect on marriage rates in the country. In the central city of Yazd, a very conservative city, religious city, for example, no major transformation with respect to early and arranged marriages had taken place despite the rising levels of education. The national data on the mean age of marriage showed that during the 86 to 96 decade, the mean age of women at marriage increased from 20 to 22 years in urban areas, continuing to rise to 23 years by 2002. The latest year we have the statistics for. Among the most important factors explaining the increase in the minimum age of marriage are rising literacy rates and levels of female education separate from Islamic education. The percentage of girls enrolled in primary schools, for example, has increased considerably in Iran, from 52% in 1970 to 91% in 2002. In 1970, more than half of all youth aged 7 to 15 had been illiterate. Today, the percentage is over 80%. The imposition of unrealistic Islamic codes has generated a strong response from those women who want to claim their rights by working within the system. This is to the point of Bob and Nathan's about the gender reactions to the Sharia, and that has taken place in Iran. The results have been a lively and still unfinished debate over competing visions of male-female relations and the status and rights of women in Islam. The debate has in turn given rise to new voices for the spiritual, professional, and social equality of men and women. Some proponents of these views have called for more women mujtahids, arguing that the clerical establishment is dominated by males who have little understanding for women. Again, this is unprecedented in an Islamic country. The shortage of women mujtahids has led some to create religious seminaries funded by women for particular education of the women mujtahids. In 1996, out of 62,000 students in religious seminaries, close to 10,000, or 16%, were women. Of these, 34% were of 20 to 24 years of age, and 20% were in the age group 15 to 19. Almost 90% of the women resided in urban areas. In the similar reaction, there was a seminar held on August 27, 2006, called Impact of Law on Women's Lives. A group of women activists launched a campaign called 1 Million Signature demanding changes to discriminatory law. Again, an unprecedented grassroots campaign led by women where urban-based and women armed with petitions began to go to wherever other women gathered, schools, hair salons, doctors' offices, private homes, to collect signature, to reverse the discriminatory laws of the family protection laws that were adopted. Let me just jump to a little bit of the reaction to the Islamic Penal Code now. The clerical regime wasted no time to draft the Islamic Penal Code for the Islamic Republic starting in 1980s and continuing given up to today under the conservative government of Ahmadinejad and the conservative leadership of the parliament. The Islamic Penal Codes are still being revised, ratified. But the Iranian Islamic Code, again, similar to the Iranian Family Law Code, has been criticized for its harsh punishments and interference in the matters of individual privacy and liberty. But most important to the point that Nathan and Bob mentioned, it has created a new public space for non-clerics to enter the debate, to discuss the norms of the Islamic punishment, something which was completely monopolized by the scholars, by the religious scholars. For example, under the code, death penalty can be applied to the following offenses: spreading corruption on earth, political offenses, armed robbery, kidnapping, rape, adultery, incest, coerced sexual relations of a non-Muslim man with a Muslim woman, and sodomy. Capital punishment can also be applied for apostasy, although the punishment is not specified in the penal code. Yet in an unprecedented publication by a person who has had an impeccable revolutionary credential, his name is Ahmad Baghi, he wrote a book called Haqq Hayat, The Right to Life. In this book, the author specifically argued against the capital punishment in Islam. Having been a former Revolutionary Guard who fought in Iraq, the clerics had a hard time questioning his credibility. And his book became a bestseller in Iran and among the young clerics who started reading it about how to suspend and abolish capital punishment, even according to Sharia. Baghi argued that there is no such absolute requirement for death penalty within Sharia or the Quranic verses. According to him, in cases of murder with the punishment of qisas or retribution, the Quran does not mandate capital punishment. In a letter to the head of the Iranian judiciary, he wrote, "The killing of a human being is both the source and propagator of violence and has no relationship to kind-heartedness, a caring society, and the benevolence of the Creator," unquote. Now, my time is up. In conclusion, the experience of the Iranian regime makes us think again about Sharia and the location of Sharia in a public space and politics. The Iranian clerics have had a hard time implementing the precepts of Sharia in a modern context, and the continuous evolving civil society in Iran, which is moving toward a separation of religion and politics, has brought the reactions of anti-clericalism in Iran. Most researchers in Iran indicate that there are less people who subscribe or attend Friday mosque, less people fast during the month of Ramadan, and less number of youngs even do their prayers on a regular basis. So these researchers and these indications are important signals to the clergy in Iran, and also an important signal to those outside of Iran who are thinking of politicizing Sharia and incorporating it in a modern state. Thank you.
Thank you, Bahman. Our last speaker in this first panel this morning, before we open to general discussion and then take a coffee break, is Hakan Yavuz, also from Salt Lake City, in this instance the University of Utah, talking about Turkey, Islam without Sharia. I'm not sure he's going to stay with that title, but we'll do it.
Well, yes, Islam without Sharia. What you have in the case of Turkey, ethical, not legal Islam. I think this very much summarizes the way in which Islam evolved in Turkey. Let me cite two quotes. One is from Recep Tayyip Erdogan, the Prime Minister of Turkey. He was in Egypt. He said on the Egyptian TV on September 14, "In Turkey, the constitution defines secularism as an equal distance to different religion. Secularism absolutely doesn't mean atheism. I, Recep Tayyip Erdogan, consider myself as a Muslim, but I am a prime minister of a secular country. In a secular system, people have freedom to be a believer or an unbeliever. I hope to see a secular constitution in Egypt because secularism doesn't mean animosity against religion. Don't afraid of secularism. I hope that the new system in Egypt is going to be a secular." And he says, "I hope my statements on secularism would change the opinion of Egyptian public." So this is the statement of pro-Islamic Prime Minister of Turkey. The second statement is from Fethullah Gülen. He is one of the leading scholars of Islam in Turkey and the most powerful Islamic movement. He says, "The problem of Muslim countries is not the lack of Sharia, but rather weak faith and the lack of morality." So what you have here is that a type of Islam in the case of Turkey is defined not against, but Islam without Sharia. Most of the Turks, they consider themselves as Muslim. I think this, the way in which the identification with Islam is in increase, but the less people are in favor of Sharia. Then the question becomes, why is the Sharia debate is missing in Turkey? What explains this new form of Islam free from Sharia? I will try to answer these two questions, and then in the end, I want to develop as some kind of typology to simplify in a way to make the debate on the Sharia somewhat easier. In the case of Turkey, I would say that the debate is not about Sharia doesn't have very positive connotation because it had to do with the Ottoman system. In the Ottoman the period, the Sharia had the dual role. On one hand, it was an instrument in the hand of the state to civilize or oppress the heterodox group. But the same Sharia was also used by the local groups to challenge the authority and oppressive excesses of the Ottoman system. With the Tanzimat, with the reforms or the modernization of the Ottoman Empire, what we are seeing is this major tension between religious scholars and modern educated secular elite. And most of the reaction to late Ottoman reforms or the rebellion or reforms framed in Islamic language, and usually people argue that we return to Sharia became an opposition to modernizing reform, and the Sharia signified what Yaşar Nuri Öztürk argues. He is one of the leading liberal Turkish Muslim scholar. He says Sharia is the way of yesterday. It is not the way of the today. Certainly what Yaşar Nuri Öztürk says, there are some other scholars, they react to that. But I would argue that in the case of Turkey, because of the history of modernization, because reaction to Mustafa Kemal's reform, very much framed in the name of Sharia, the Sharia became an anti-government, anti-order movement, and it lost, as a term, it lost its credibility. I would argue that there are two major patterns in the Muslim world, what we see, or one major form of politics, what I call it as Sharia politics. Second is at the democratic, more civil-oriented Islamic pattern. In the first pattern, where there is a cry or call for Sharia, there are a number of characteristics of these societies. One, I would argue that if society hasn't achieved national integration, if state institutions are too weak, and if the rule of law and state cannot provide a justice, if economic system, if there is no middle class and economy is not well integrated into global system, and in these societies where these four conditions exist, there is more demand or call for Sharia. In other words, the Sharia debate or type of Islamic interpretation we get is very much the outcome of these four contextual conditions. In a situation where you have a powerful state and relatively successful national integration and the inclusion of opposition groups and opposition forces, there is a more free political space, and then you have a type of economy which is fully integrated into global economy, you are not going to hear much debate or call for Sharia. So call for Sharia in Afghanistan, in Pakistan, in some African societies, including in Yemen or in today's Iraq, is, I would say, very much call for law and order. One of the main purposes to create an institution, since the state institutions are too weak to distribute the justice. Now, when you come to the Turkish case, it also played an important role. Finally, the Islam in Turkey, I would say Sufism or the Sufi character, both Prime Minister Erdogan, he was a Naqshbandi, and Fethullah Gulen, I consider him as a neo-Sufi. So the Sufi type of Islam tend to put more emphasis on inner side than the externalities of the law or the external rules. Finally, I would say the most important factor, what type of Islam we are going to see in the future very much depends on the economic structure. In Turkey today, the vanguard of Islamic movement are new bourgeoisie, what is called Anatolian tigers. If you do not have a developed independent economic structure in a given society, if economy is a rentier economy very much tightly controlled by the state, if you are not going to have a powerful bourgeoisie to balance the excesses of the state or the official Islam, you are not going to get a liberal, competitive Islam. To conclude, I don't want to take much of your time, I would argue that we are going to see a more liberal, pluralistic Islam if you have a powerful state institutions with the civil society. Second, if you have a vanguard of Islamic movement are merchants, not the military, not the ulama, but the business class, because in that competitive economic structure helps to create a competitive religious space, that you have different visions and versions of Islam are in competition. The third, if you have a competitive political system which plays a very important role, forces both the religious scholars and politicians to redefine Islam that would appeal to the masses. Finally, in the case of Turkey, I would say the external factors, the European Union conditionalities played a very critical role. As Turkey becomes more modern, as Turkey becomes more democratic, Turkey also becomes more Islamic. But this Islam is not the Islam of 1950s or 1960s. This is something very new Islam, I would argue. That it is new in terms of it doesn't demand a Sharia or an Islamic state, but Islam as a bonding in terms of Islam as a new social glue of social integration both within the country and also integration with the outside world. You will see in the actions of the Fethullah Gulen community that it is more ecumenical type of Islam to bridge. So you bridge, on one hand, you utilize Islam to consolidate and create a moral language within the country, that Islam becomes a grammar of morality in the country, but at the same time, same Islam doesn't exclude you, but it becomes a bridging factor with European Union, with the United States, with different religious traditions. So what we have here, I would say, a type of Islam, it is about identity, it is about morality, it is about bridging with other religious traditions, rather than debating or discussing how to, about the capital punishment. All these issues are very much, because Turkey wants to join the European Union, so the capital punishment is not part of the legal system. So you have a very different debate of Islam. And to last word, not because I am from Turkey that I am saying this, but I will say the past of Islam in the Arab world, but the future of Islam is in Turkey, Indonesia, Malaysia, Tatarstan, and Bosnia. I will end here.
Thank you. There's a lot there to discuss. And the floor is open for discussion and comment. mind, could you identify yourself when you...
My name is Caitlin Mead. I'm a research associate with the Public and National Law Policy Group. And my question finally is from Egypt and Turkey. I see kind of a parallel coming between the debate between Sharia and Islam in those countries specifically, and kind of the more current debate we're having in this country with just a new fundamental religious uprising, particularly with gay rights or abortion, and the debate that they're having in those countries. Do you think that exists, or is there a parallel, or not really?
I didn't get the.
Nathan, you want to lead out on that?
Yeah, let me try. I think there may be some parallels. I'm not sure anybody involved in those debates would like to admit it. If I understand correctly, there's certainly. I'm going to answer the question in an odd way and hook it into what we heard the statement of Erdogan when he went to Egypt about hope that Egyptians endorse secularism. Egyptians were really confused when they heard this Islamist leader come, and it was as if Margaret Thatcher had come to the United States and started talking about the virtues of socialism. What is going on here? And in a sense, I think what is going on is an emergence within some Islamist circles of what could be called secularism, but what could also be called Islamism, in ways that has some parallels to debates in American political life. That is to say, individuals from religious traditions and religious communities certainly draw on the teachings of those religious communities or of their religious traditions when they advance positions in political life, but they do not ask for sort of state enforcement of any kind of religion. So they're not asking for an official religion, but they're simply saying when making decisions on public policy issues, that's where we go to. And in a society where the vast majority of people come from a specific religious tradition, that will naturally influence public policy and perhaps the course of legislation. So you can call that secular because there's no official religion. On the other hand, it is public policy and law can be deeply informed by or religiously inflected. Interestingly, in the Arab world, I won't touch the question of about where Islam's future lies. I'm not an Arab, I'm not a Turk, I'm not a Bosnian, I'm not a Muslim, so I have no stake in that debate. But when I look at debates in the Muslim world, and when I hear talk about secularism coming up, or this kind of approach coming up, it actually comes from Islamist, what I would call kind of left-wing Islamist circles. Ghanouchi in Tunisia can talk this way. Some people who've left the Muslim Brotherhood in Egypt can talk this way. And I think they're attracted to the kind of Islamism that Erdogan represents, even if it's not even if you wouldn't necessarily even call it Islamist, and that would again be recognizable, I think, to many Americans. Obviously not Islamism, but in terms of Christian political activism. I hope that answers the question.
Hi, my name is Ling, and this question is for Nathan Brown. I have a question. You mentioned in your earlier speech that there's some more emphasis on personal behavior in Egypt. How do you think this new emphasis, new awareness, will permeate political change and social change?
It's a great question, and I'm not really sure I can answer it because I don't know where it's going. It takes so many different forms, and I don't even know how widespread it is. Partly because, as I said, I'm a political scientist, so when people start talking, sort of quietly studying religion by themselves and quietly changing their personal behavior as a result of their understanding of religious teachings, I don't notice it until they form a political party, elect people to office, and that sort of thing. So I can't tell you how widespread it is. Egyptians talk about it a lot, and I've run into certainly plenty of Egyptians who are very interested in participating in this in all different kinds of ways. But what its long-term social and political significance is, I just can't tell.
Sorry. My query is directed to Mr. Hakan Yabuz. I agree with him when he says that the Arab countries represent the Islamic past, and Turkey, Indonesia, etc., represent the future. I don't dispute that. But how is it that in the Western discourse on Sharia and Islam, one of the most pious Muslim countries, perhaps also the most liberal democratic country, Bangladesh, is left out? I simply don't understand this phenomenon. Thank you.
I think you are. I think you are right that I don't follow much what is going on in Bangladesh, but I agree with you. I just those countries came to my mind, but I agree that is an important case.
As the initiator of this project, I probably have some responsibility for that error. We had originally imagined an even more ambitious project with a greater number of countries. It's not just Bangladesh that stands out as a fascinating case, but it's countries like Senegal. Senegal, where we have, which is, as far as many Americans is concerned, is more or less off the map of the Muslim world and probably not very important. Well, it is very important, just as Bangladesh is very important. Just as Bosnia is very important. There are many countries that didn't figure in this project. And it was a reflection of a couple of things. One was a conviction on the part of myself and some of the panelists, some of the participants in this project, that we wanted to focus on those countries that were of, in policy circles, greatest perceived urgency. Whether in fact they were urgent or not is another question, and I'm not making that argument. But the second thing is that we didn't get the full funding that we asked for. So we scaled back. Indeed, we were going to include a study of Sharia discussion and debates in Western Europe and the United States. And all I can say as regards that is, and this is an advertisement for the Institute on Culture, Religion, and World Affairs at Boston University, please stay tuned. In the back. John Esposito in the back, please.
Oh, sorry. Good morning. My name is Jean-Sébastien Mar. I'm a student here at Georgetown University. My question is for Mr. Bakhtiari. Do you think that the Iranian theodemocratic system could survive to a potential decrease in the implementation of Sharia law in the country?
Well, that's a very important question for policymakers, isn't it? I think that Islamic Republic's political system has certain ingredients that encourages and facilitates debates, factionalism, pluralism, contestations. And what the founders of the Islamic Republic did not take into account was the fact that the growing number of religious scholars who were tasked with these debates have been pushed aside, with secularly derived scholars who come and use the Islamic language against them now. So I will say the Islamic Republic will survive as a system, but actors within it will change and evolve. We will see a decrease in the number of clerics in politics. The Iranian parliament had 130 clerics in the first session of 1980 to 84. Today has 32 clerics. So if one looks at the representations, electoral changes taking place in Iran, there is a tendency to select technocratic leaders. The president is a non-cleric, the speaker of the parliament is a non-cleric, and majority of parliamentarians are non-cleric. So I would say Islamic Republic will transform itself to become Islamic, similar to the Chinese model that is Marxist, but it will maintain the symbolism.
Yeah, just to follow up on Hakan's comment, Richard Bullitt at Columbia has written a good deal about the importance of the periphery versus the center in terms of the development of Islam, rather than the center being simply Arab center. Indeed, if one looks at reformism today, one could argue that a great deal of the really interesting progressive reformers and writers, and if you look at literature, come out of places like Turkey and Bosnia and Indonesia. But I think what could drive it home would be if you were to quote one of my former students, who you know very well, but whom I won't mention today, his name, who once said in a Georgetown setting to students from the Arab world who were constantly talking about the centrality of the Arab world and how one needed to be Arabized. And I remember being in a meeting in Turkey in which a former distinguished Arab foreign minister was saying the same thing to Turkish and Indian Muslims, that the Muslim world had to be Arabized. This student, now a professor, said, "But you don't understand. The miracle of Islam is that God revealed the Quran to the Arabs, and yet Islam continued to survive."
Can I add something to? Well, I think what is important here, really, I agree with John that this whole context and text debate, that the religion, whatever religion we are talking about, that the democracy, we all discuss about the impact of religion on democracy, impact of religion on economy, but I think it is time to look at the impact of market economy, democracy on religion, especially Islam. And what we see, that it is time to, in a way, reverse Max Weber's thesis that what we are seeing in Turkey, a new type of Islam is emerging. It is possible to call this Protestant Islam, but this is outcome of the market conditions, and there's a new opportunity spaces in the media, in the political, in terms of democratization, in terms of the economic wealth, expanding economy. All this structure, the context, I would say, restructured or reshape the meaning of Islam. What Islam means in Turkey today is not an instrument of jihad against European Union, but Islam somewhat, the way in which it is imagined, a linkage to European Union, the path to European Union. This is how they see it. The Turks, some of the Europeans certainly see it totally in a different way. But there is a different, this whole bridging, the religion as a way of bridging with other traditions and seeing yourself as a member of the global community, rather than religion becomes an enclave culture. I think this is, but there are some societies Islam is enclave in Afghanistan or some parts of where I would say the social structure is so weak and states are fallen. But then you have also other form of Islam. I think this new form of Islam is very much, I agree with John, that the periphery, because where the economic dynamism and there is a political expansion is taking place, we are seeing a new type of Islam.
Yes, please.
Good morning. My name is Knox Thames. I'm with the U.S. Commission on International Religious Freedom. Just big question. Any insights on how the U.S. government, when it's engaging other countries on issues of human rights, of religious freedom for the majority faith, for minorities, for women's rights, for civil society, when Islamic law is being enforced by the state in ways that abridge those fundamental freedoms, any advice on how we can effectively have those conversations to move them in a way that those fundamental freedoms are respected?
Well, but it is a coincidence, but it's a happy coincidence that later this afternoon there's going to be an entirely separate conference here in this room. That's one of the reasons we have to exit so quickly, in which I also happen to be participating, but it's an entirely separate project, and it's on international religious freedom and the kinds of policy questions that come up as one aims to promote an international human rights regime. Many of the cases are Muslim, many of the findings that will be discussed at that meeting resonate with what we found here. And there's a number of things to be said, but the first point is the one that I said in my opening statement. I will stand by this, but it's very banal in some ways, but it's very, very important. And one is to recognize that the plurality of interpretations of Sharia is real. It is competitive and contested, and it's influenced by many of the same political, economic, educational, and women's and family issues that affected the reorganization of religion, public religion in particular, the public rule of religion in the West. There's been, as I work at an institute, we do work on evangelicals, we work on Catholicism, Buddhism, the religious revival in China and East Asia generally. What is striking, I think, but often overlooked, is the way in which the same forces, many of the same forces that so dramatically transformed public religion in the West have affected and are affecting the discussion, debate, and public role of religion in the Muslim world. So that's the first thing, and unfortunately that's a cautionary. It's both a positive statement but a cautionary statement. The cautionary statement is don't fall into the trap of indeed inadvertently subscribing to what is a rather radical Islamist understanding of Sharia, that the Sharia is fixed and intelligible, and that anybody who says otherwise is an apostate. That's basically the message that comes from Al-Qaeda, and it comes from other groups. But the second thing is what makes your job, I think, and I have a lot of respect for your commission. Indeed, a colleague of mine, Elizabeth Prodromou, sits with you, so I have great respect for you. But one of the things that complicates policy analysts in general, as opposed to the commission's task, is that there is, if you will, a policy decision to be made as to, if you will, the kinds of actions on the part of Western governments that can have a kind of midterm and long-term effect, and those that, if you will, have to be in an immediate sense addressed. You're more in the business of, and it's a good business, of jumping in and saying, look, here's what the state of human rights is in your country, and we see an inconsistency, a contradiction, a tension in these fields, and we're going to say that. Conversely, other U.S. policy makers and programs, I think, will want to recognize, have to recognize that they have a long-term sense, a long-term investment in change, not just in the Muslim world, but around the world. And that once again, educational reforms, Hakan's emphasis on economic development, but an economic development that is pluralizing, more specifically pluricentrizing in terms of its impact on the social landscape. That these things, it's not just for the future, it's these things that have already so dramatically transformed the nature of discussion, the understanding and practice of Sharia in so many lands. The general current is, of course, a greater publicization, and then a very powerful current, but a contested current, is citizenization. That's what I think policy analysts want to keep in mind. But inevitably, there will be, if you will, two tracks, policy tracks, yours, and then another one that's aiming to sort of engage the kinds of broad institutional investments that make a difference in the public profession of religion in the Muslim world, just as was the case in the West, not least of all the United States. Nathan.
So I think, yeah, I'm the only person on this panel who lives in Washington, so I can't resist a policy question. And I would say, I mean, I would agree with what Bob said, but I would say two other things that are probably a little bit more kind of nuts and bolts as well. Number one, there is some internet or religious freedom issues can cut any number of ways. And I think it's a mistake to see them as religious freedom on the one hand and Sharia on the other, when religious freedom issues get some traction within even some of the, I would say even among Islamist movements. It's when they realize that they can present some of their own arguments in religious freedom terms, okay? So whether it has to do with restrictions on dress and this sort of, or on political parties, forming on the basis of religious teachings, these sorts of political activity that has a religious basis. these are the sorts of things where, in a sense, you know, when I was talking about an emerging, you know, quasi-secularist trend within Islamist circles, that's the reason and that's the motivation it's made. It's that essentially what has happened is the state has come in and tried to take over religion, and we are not allowed to practice our religion faithfully in countries that call themselves Muslim, and there are growing restrictions on religious practice for Muslims, or attempt to restrict religious practice for Muslims in non-Muslim non-Muslim majority places, and an attempt to cast the arguments in again in terms of religious freedom. All we want to do is practice our religion. And I would say that if for international organizations or governmental organizations that are involved in international religious freedom issues position themselves in the debate that makes clear, in a sense, that they are for religious freedom for all people, for all believers or non-believers, that actually can have some traction. That's the first point that I would want to make about religious freedom issues. I will just, well, no, the other thing that I would say is that the debates that we have been talking about here are very, very real. And they're very active debates within the societies. I think there are reasons why a U.S. government organization can't participate. I mean, it's not the position of the U.S. government to say that interpretation of Sharia is correct, that approach to Sharia is wrong. We cannot do that, and a government commission couldn't do that. And I think there's good reasons to stay away from them, even if we could do that. We can't really intervene in those debates. What we can do, or what I think people who are on the outside with international organizations or with government organizations can do, is simply hammer away on the principles. These are well enshrined. Various principles of liberal freedoms in general and religious freedoms particularly are well enshrined in sort of international practice and international instruments of various kinds. We don't have to intervene in debates on how those are compatible with various understandings of the Sharia or not. We can just ask over and over, but what about, but what about, but what about, and let the debate play itself out internally as it will. And asking the question over and over and over actually has some, I think, some indirect influence on the debate.
Time for one more question, and then we have coffee.
Thanks. Joshua Hendrick, Loyola University of Maryland. These questions, although geared directly to Hakan, third one especially can be answered by everybody, or can chime in first. I'll get through them quickly. I think it was 1994 when another quote, while Erdogan was mayor of Istanbul, he said, "Thank God I am for Sharia," to paraphrase, not a direct quote. So easy question, or easy way to phrase it. Has power secularized Turkey's Islamists? Or how do we interpret the shift towards essentially what is said in Egypt, which is, thank God for secularization, which then leads to the next question. There's a fundamental difference, as I see it, between secularism and Turkish laicism. Secularism on the